On the line with us is Maya K. van Rossum, an attorney, activist, executive director, and original organizer of the Delaware Riverkeeper Network. Maya is the author of a new book, The Green Amendment, Securing Our Right to a Healthy Environment. Maya, welcome to the program.
Thanks so much for having me.
Thanks for joining us. Am I saying your last name right?
Yes, you are.
Okay, great. So are you talking about an amendment to the Constitution of the United States?
What I'm talking about is amendments to the state constitutions. I think we need to start at the state level first, and then ultimately at some point down in the future, we'll be ready to look at the federal constitution. But right now we're talking about amending state constitutions to recognize and protect the inalienable right to clean water, clean air, and a healthy environment.
With the federal supremacy clause that says basically federal law trumps state law, it's fairly easy for the federal government, and particularly the Supreme Court, to simply assert that a state law is not in compliance with federal laws, or even a state or a state constitutional amendment. Several have been struck down in the last few years. How do you prevent that?
Well, so the state constitutions, right, impact state action, state decision-making, the passage and implementation of state laws. And we actually have, in the Commonwealth of Pennsylvania, we have a Bill of Rights provision that recognizes and protects the right to pure water, clean air, and a healthy environment, and mandates constitutionally through the state constitution that state government officials, whether they're elected to office or they're regulators appointed to office, carry forth their constitutional obligation to recognize and protect the people's right to a healthy environment. So that doesn't get trumped by the federal constitution, right? Because the state constitution guides and impacts what state officials are doing pursuant to state law. And that's really powerful when you're talking about the environmental arena, where so much is up to the states to handle and deal with.
So are you suggesting that other states should adopt Pennsylvania's constitution, or that portion of Pennsylvania's constitution, or is this a completely separate amendment that you're proposing for all the states, including Pennsylvania?
Yeah. So what I'm proposing is that every state craft and add to it the Bill of Rights section of its constitution, its own state constitutional provision, but that has basic minimums, like recognizing and protecting the right to clean water, clean air, a healthy environment. Pennsylvania's provision is a good model, but frankly, right now it's not the best model. We actually have a constitutional amendment moving in the state of New Jersey, which is even more protective, more beneficial in terms of language than what we have in Pennsylvania. And amongst the things that it does differently and better is it actually recognizes climate rights, right? The right to a stable climate. So Pennsylvania's provision was passed in 1971. It only got legal life in 2013 as the result of litigation that my organization, the Delaware Riverkeeper Network, successfully pursued along with 7 towns. But when it was originally crafted, right, it sort of predated, while there were many of us who were aware of climate change at the time, for the vast majority of people, right, it was a new concept. So that didn't actually make it in Pennsylvania's provision, but it needs to be in other provisions today.
Have you been working with Thomas Lindsay and CELDF on any of this?
So CELDF is a wonderful organization. They actually have a different approach, right? We are looking to use the recognized, powerful, legal constitutional pathway for recognizing and protecting the right to a healthy environment. CELDF has a great concept, but it's different. So, too, there are a lot of other great concepts, like the rights of nature and the Oregon climate litigation that's advancing by our children.
Juliana case, yeah.
That's right. Great concepts, all value added, but they are different concepts than using the strength and the power of our state and federal constitutions to recognize and protect as inalienable the right to a healthy environment. So we recognize and protect our environmental rights in the same way we recognize and protect other fundamental freedoms we hold dear, like the right to free speech, the right to freedom of religion, private property rights, due process rights, and so on.
Right. So you're not asserting that nature has rights, that frogs have rights, that the environment essentially has rights, as some, including CELDF, have suggested. You're asserting that kind of the back way around that is to say that we have a right to clean air, clean water, a clean environment, a stable atmosphere, a stable environment. And the consequence of that, of course, would be that the rights of nature are more aggressively and effectively protected. Do I have that right?
Yeah, you do. But on the other hand, they're also not mutually exclusive. So one of the states where I'm speaking with folks, they really passionately believe in the rights of nature, and they would like to have that kind of language included in a constitutional amendment that they're hoping to advance in their state. So one of the things that I've done is work with them to figure out the right language for including that concept in the amendment that they would advance. I think including the rights of nature is powerful and important if you can get it passed, but it does change the picture, and in many ways it will raise the bar. And I don't think it's necessary to get, just as you just said, to get this powerful level of constitutional protection for our environment. We don't have to include the nature's rights explicitly, but to some people it's important. And if it's important, then it can be done.
Put it in, yeah. So game this out with me. A state adopts a constitutional amendment that includes the right to a stable atmosphere. That state, that gets adopted. The good citizens of the state then bring a lawsuit against the state for allowing fracking, which is destabilizing the environment. The frackers sue, or in fact, they may initiate the lawsuit actually, saying, "Wait a minute, you're infringing on our ability, our right to contract, our right to do business in this state." Which is heavily protected by the Constitution and the Supreme Court. Historically, the Supreme Court has almost always put property rights and business rights above individual human rights. And the Supreme Court says, very nice amendment that you've got to your Constitution there, but you can't take away the rights of the fracking companies. We're gonna strike down that provision of your Constitution. A, do you think that that's a reasonable characterization of what might happen? And B, how do you respond to that?
So first off, I just want to remind people, right, that, again, I believe that we start at the states. So when you talk about the Supreme Court, we're actually talking about state Supreme Courts. The federal Constitution is down the road. I believe we will get there, and we have to get there if we want to hold Congress and the president accountable.
The U.S. Supreme Court can strike down provisions of individual state constitutions, and they have done that in the past.
But what we're talking about here, primarily in the implementation of the state constitutions, right, it's going to be holding states accountable. So the place that we're going to begin is with state actions and at the state level.
No, I absolutely get that. But how, if the federal government decides to insert itself, how do you respond to it?
But I don't think that we're going to, frankly, I don't think that we're going to get to that place, right? So in terms of the state constitutions, right, the states have a very powerful role to recognize and protect the rights of the citizens, the rights of the residents in their state. And I truly don't think that we're going to be getting to a situation where we start having the federal government knock down state constitutional provisions because they are guiding the way state activities happen. And one of the things to really recognize, I think, in the scenario you're talking about, is right now when you talk about industry, and their private property rights, for example, the fact of the matter is they have a tremendous leg up on the people, on the challengers of their actions and activities, because there is no counterbalance in the Constitution when it comes to the environment. Corporations and people have property rights, but other than in Pennsylvania and Montana, where we have the kinds of green amendments that I'm talking about, you don't have an environmental counterbalance. And so they have a much stronger foothold legally, constitutionally, than the challengers do. What's happening in the Commonwealth of Pennsylvania, since we breathed legal life into the Green Amendment, the Environmental Rights Amendment in the Pennsylvania Constitution, is that the courts are now recognizing that there's actually a counterbalance to private property rights and the other rights that industry and others are claiming. And as one judge in the Commonwealth of Pennsylvania put it, the Pennsylvania Environmental Rights Amendment now puts a thumb on the scale for protection of the environment when you've got this struggle between property rights and environmental rights. So it really is very powerful.
So you're not concerned about the Supremacy Clause?
No, I'm not. I don't think that we're going to be hopping to that place. I think when we start, and we haven't experienced that yet, right? We have green amendments, powerful green amendments in Pennsylvania and in Montana, and we're not seeing industry trying to advance the kind of claim that you're talking about. And truthfully, if there was that kind of claim, I think that there is a strong defense against it, right? Because we are talking about the states' rights through their constitutions and through constitutional law to guide the actions and activities of state legislators and what they are doing legislatively in their own jurisdictions, right? We have a great respect here in the United States of America for states and states' rights. Therefore, they have tremendous authority through their constitutions and through litigation to regulate in certain areas. In the area of the environment, the law explicitly recognizes, when you're talking about the Clean Water Act, the Clean Air Act, and so much other legislation, the laws explicitly recognize the rights of the states to protect what is happening with their borders environmentally.
Fascinating stuff. Absolutely fascinating stuff. Maya K. van Rossum is the author and also the Delaware Riverkeeper. The book, The Green Amendment, Securing Our Right to a Healthy Environment. You can tweet her at Del Riverkeeper, and the website Maya van Rossum, ROSSUM.green, and DelawareRiverkeeper.org. Maya, thanks so much for dropping by today.